Ladies and gentlemen, a very good afternoon to all of you. We begin this webinar in the next 1 minute. Ladies and gentlemen, Devyar Sajjano, a very good afternoon to all of you and welcome to this webinar. My name is Ajay Thomas and I'm the Director of the Faculty of Law at Manav Rachna University. At the very outset, let me take this opportunity to thank all of you for your support, your great support to this initiative, which is the third in a series of extremely successful back-to the practice of law. The first in a series of webinars was a masterclass on the fundamentals of pleading by Justice Pradeep Nanda Jog. The second was on the essentials of examination in chief and cross-examination in a civil trial by Justices Rajiv Sahai N Law and Justice Pradeep Nanda Jog. And in today's seminar, we will be focusing on how to claim damages under the Indian Contract Act. Ladies and gentlemen, it is said that the law of damages is big business, which deserves a big fat book. To condense that big fat book into an hour's worth of knowledge, we're delighted to have with us today a sitting judge of the Delhi High Court and a leading commercial senior advocate also practicing at the Delhi High Court. Here's a little more about our distinguished speakers for today. Our first speaker is Mr. Justice Jayant Nath. Justice Nath is an alumnus of Delhi Public School, Mathura Road. He holds a BA Honours in Economics from St. Stephen's and an LLB from Delhi University. For almost 25 years, Justice Nath practiced as an advocate at the Supreme Court of India, the Delhi High Court, and various other tribunals. He's also a trained mediator and was designated as a senior advocate by the High Court of Delhi in 2006. And shortly thereafter, he was appointed as a judge of the same court. When he's not poring over pleadings and dissecting the arguments of counsel, you will find Justice Nath playing a good game of badminton or a nice, relaxing game of golf. Ladies and gentlemen, our second speaker is somebody you've seen quite often on the television, that is, Mr. Amit Sibal. Mr. Amit Sibal is a senior advocate designated by the Delhi High Court. He did his BA in Philosophy, Politics and Economics from Oxford. He holds a law degree from Cambridge and a master's in law from Harvard. Thereafter, he worked with a large American law firm, Davis, Polk and Waddell, first in New York and then in Hong Kong. Ladies and gentlemen, to moderate this webinar, we're delighted to have with us two rising stars of the Delhi Bar. Ankit Jain. Ankit did his schooling from Cambridge School. He's a product of Amity Law School and has been practicing in the Delhi High Court and various tribunals for the last 15 years. Presently, he's a standing counsel for the Delhi High Court and represents the Delhi High Court whenever the Delhi High Court is hauled up in a court of law. He has conducted matters in a broad spectrum of legal fields. He's also a trained mediator and acts as an arbitrator in various matters. Our second moderator is a young but extremely experienced Vaibhav Agnihotri, who is a partner with SKV Associates. Vaibhav now has developed a niche practice for himself over the last 10 years at the bar. The core areas of his practice are contract and service law, and he also represents several multinationals in litigation and arbitration. Now, ladies and gentlemen, before I would hand over this webinar to our moderators, I would like to thank Bar and Bench for being the media partners for this event and for their coverage of this event. Ankit and Vaibhav, gentlemen, it's all over to you now.
Thank you, Mr. Thomas, for introducing our two panelists who otherwise require no introduction. We know them throughout our legal profession. We see them day in and day out in court. On that cue, may I request Justice Jagannath to begin and give us his views about the topic.
Thank you very much, Mr. Ankit Jain, and thanks a lot, Mr. Ajay Thomas, for all the kind words that you have said about me. A very good afternoon to my distinguished co-speaker, Mr. Amit Sibal, Senior Advocate, and to the other two coordinators, learned advocates, Mr. Ankit Jain and Mr. Vaibhav Agnihotri. And last but not the least, a very good afternoon to all my friends who are virtually with us today in this meeting. It's a Friday evening, 3 p.m. here, and a lockdown is also going on. So I tried to persuade the organizers that it may be a siesta time for some of us. Unfortunately, I was not able to persuade the organizers. So here we are on a serious topic on back to basics claim for damages. That is the topic, and believe me, I have taken it literally. My presentation is a basic introduction to the concept of damages. I have not taken up any technical or elaborate subject, and I've tried to keep it as simple as possible. When you look at the Indian Contract Act, what is it that would strike you first? What fascinated me was that it reads the Indian Contract Act of 1872. So what does that mean? It is almost 150 years old. That's a long time ago. 150 years ago in 1872, perhaps most of India would not even have had electricity or mechanical vehicles to move around. But in my opinion, the statute has stood the test of time. The provisions are clear. They explain the concept of contract, damages, etc., all in a very simple and clear manner. There are two main sections in the Contract Act which I will deal with, namely section 73 and 74. These are the sections that deal with calculation of damages in case there is a breach of contract. So, when does the issue of damages arise in a contract? There are three mandatory conditions. First is obviously that there must be a contract between the parties. If there is no contract, there can be no breach of the contract. Secondly, as I said, there has to be a breach of that contract. So two twin facts are, first there must be a contract, there must be a breach of contract, and the third element is damages. The party who has suffered from the breach of contract has to suffer damages. In the absence of these three ingredients, section 73 and 74 would not arise or would not be attracted, and a claim for damages may not arise. I may first have a little close look at section 73 of the Act. In simple language, it spells out the compensation payable to a party who suffers from breach of contract. Section 73 is compensatory in nature. There is no compensation provided for issues like loss of reputation, anguish, etc., that a party who suffers from the breach of contract may have suffered. The innocent party has to essentially be placed in a position as if there was no breach of contract. The section provides two mechanisms to quantify the compensation payable to the party who has suffered. Firstly, the compensation is such which naturally arose in the usual course of things from the breach of the contract, or such compensation will be awarded when the parties knew when they made the contract to be the likely result of the breach. There are number of illustrations given after Section 73 of the Contract Act, which in a way explain the consequences of the magnitude of the said section. I thought for today I would deal with two of the illustrations just to illustrate how the Act really, how this particular provision really works out. One illustration states that a contractor, Mr. A, agreed to repair the house of B in a certain manner. He was paid the full consideration. He did not repair the house. The contractor did not repair the house in the manner as it was agreed upon. So the house owner, what compensation can he claim? I think this is the simplest illustration that can be given in the Contract Act, and perhaps all of you would know the answer. The house owner has to be put in the same position he was had the contractor completed the house as per specifications. So whatever cost the house owner spends in redoing his house to bring it as per the terms of the contract, those are the damages which the house owner can claim from the contractor. Reiterate the provision that compensation which naturally arose in the usual course of things or breach of the contract. A second illustration I will take, namely a case where Mr. A was to deliver to Mr. B, a common carrier, some machines to be delivered to Mr. A's factory. The carrier is informed that the factory is stopped and the goods which are to be delivered are required urgently to restart the factory. The carrier delays the dispatch of the machine. A loses a valuable contract with the government. So what are the damages that the factory owner can seek? The illustration clearly states that the factory owner can only seek compensation for the daily loss of profit suffered by him. He does not have to compensate the carrier does not have to compensate the factory owner for the breach of contract that the factory owner did with the government. Again, an illustration of how Section 73 operates. There are two caveats I may just add to Section 73, which are to remedy the inconvenience. The same shall be taken into account while estimating the compensation. I need not dwell further onto provisions of Section 73. I will request my fellow speaker to perhaps dwell further into this provision. I move on to Section 74 of the Contract Act. This is a section in continuance of Section 73. Section 74 deals with a situation where a contract is broken. Yeah, can you hear me? I think the contract got broken. Am I clear now?
Yes.
Okay. I was dealing with Section 74 of the Contract Act. Section 74 deals with a situation where if a contract is broken and the contract names a sum to be paid in case of breach, or the contract contains any other stipulation by way of penalty, then Section 74 is attracted. This section has been a subject matter of numerous judgments of the Supreme Court. I will deal with three of the judgments only to elaborate how this section works. As I now said, there are two aspects which attract section 74, namely that the sum is named in the contract by way of which is payable in case there is a breach of contract, or the contract contains any stipulation by way of penalty. The first case that I would like to deal with is the Constitution Bench judgment of the Supreme Court in Fateh Chand versus Balkishan Das. This is a judgment of 1963. The facts are very simple. There was a house in Karol Bagh. The plaintiff agreed to sell the house to the defendant for a sum of rupees 1,12,000 rupees. 1,000 rupees was paid as earnest money. A sum of rupees 24,000 was paid as one of the installments. On payment of 24,000 rupees, the defendant took possession of the house. The balance was to be paid subsequently, but was not paid by the defendant. In these circumstances, the Supreme Court noted that the contract stipulated that the plaintiff is entitled to forfeit the sum of rupees 25,000 which had been paid by the defendant. The Supreme Court held no, the sum of rupees 25,000 is actually a penalty, and at best the plaintiff can recover reasonable compensation. On the facts that existed, there was no evidence to show that the price of the property had fallen. Hence, the court took the view that the plaintiff has not suffered any damages. At best, he was deprived of user of the property because, as per the agreement, the property was now to come back to the plaintiff because the transaction and balance consideration had not been paid. In those circumstances, the Supreme Court said that the plaintiff can only recover mean profit and damages, and ordered accordingly. The amount of 24,000 could not be forfeited by the plaintiff. Hence, the court categorically held that in all cases where stipulation in the nature of a penalty is provided feature, the court has jurisdiction to award only such sum it considers reasonable, not exceeding the amount stated in the contract between the parties. This is one of the basic principles applicable to section 74. The next landmark judgment, which is often quoted, is the case of Oil and Natural Gas Corporation Limited versus Saw Pipes Limited. That is a case pertaining to the year 2003. One of the issues involved in that judgment was the Arbitration Act, namely section 34 of the Arbitration Act. The controversy revolved around a contract between ONGC and Saw Pipes Limited. Saw Pipes had to supply goods to ONGC. The contract provided a stipulated damages which were payable in case there is a breach of contract by Saw Pipes. The contract also provided that the said stated amount is a genuine pre-estimate of the compensation payable by in case there is a breach of contract by any of the parties. In these circumstances, the Supreme Court held that the stipulation in the contract for payment of dues was a genuine pre-estimate of the damages that are likely to be being suffered by ONGC. The court also held that in the facts of the case, it would have been difficult for ONGC to lead evidence to give an estimate of the damages, and the ONGC recovered the stipulated amount because it was a genuine pre-estimate of damages. So essentially, where the contract names a genuine pre-estimate of damages, and the court also agrees that yes, it is a genuine pre-estimate of damages, the court would normally award the same. The last judgment which I would like to mention is that of Justice Nariman in the case of Kailashnath and Associates versus DDA. It's a famous case of 2015. Again, it pertained to a property in Delhi at Bikaji Kama Place. DDA optioned the property. Kailashnath and Associates bid was accepted and 25% of the bid amount was paid. The balance 75% was to be paid within a stipulated period. The contract provided that in case the highest bidder whose bid is accepted fails to pay the balance amount, the initial 25% would stand forfeited. The court held in those facts that no, the said amount cannot be forfeited by DDA because DDA suffered no loss or damages. Actually, what had happened was that after the contract was terminated by DDA, the property was put to auction and the DDA recovered a much higher price than the price that had to be paid by Kailashnath and Associates. So the court came to the conclusion that DDA has suffered no damages. When you suffer no damages, then you cannot claim compensation from the other side. The court concluded that the 25% amount, that is 78 lakh rupees, have to be refunded back to Mr. Kailashnath and Associates. The judgment went through the entire conspectus of earlier judgments under Section 74 of the Contract Act and culled out the legal position. The judgment clarifies some salient aspects, namely, firstly, when a contract is named, and when the contract names a liquidated amount payable by way of damages, such amount is payable if it is a genuine pre-estimate of damages fixed by both the parties and so found by the court also. So, if it is a genuine pre-estimate of damages and the court comes to the conclusion that it is so, then the same would be payable. In all other cases, only reasonable compensation can be awarded, not exceeding the amount so stated in the contract. Secondly, the court held that when the amount is fixed, is in the nature of a penalty, only reasonable compensation, again, not exceeding the amount so said. So in both the cases, the upper limit of damages is the amount stated in the contract. Thirdly, to claim damages, the party in question must have suffered loss or damages on account of breach of contract. This act dictated in the beginning itself that where there is a breach of contract and the party who suffered does not suffer any loss or damages, there is nothing for him to claim. The essential aspect of compensation is that the party has to be placed in the same position he was had there not been a breach of contract. Sorry for that interruption. And lastly, the court held that where the means exist for a party to prove the actual damage or loss suffered, then such proof is not dispensed with. It is only where it is difficult or impossible to prove the loss or damages suffered. In that eventuality, if the liquidated amount named in the contract is a genuine pre-estimate of damages, the same can be awarded without necessity of leading evidence by the party. This is the same thing that happened, as I noted, in the case of ONGC pipes, where ONGC did not have to lead evidence as the nature of the contract was such that the court held only add that judgment of the Supreme Court in Kailashnath and Associates of the DDA has been recently reiterated in the case of MTN versus Tata Communications 19. So that in substance is the provisions section 73 and 74. Before I complete my presentation, I may just refer to section 19 of the Contract Act. This section provides for a situation where particular agreement vitiated by fraud presentation if the representation has been true. So where a fraud or misrepresentation is proved under section 19, the party can seek the relief that he should be restored to the same position. The fraud or misrepresentation did not take place. Essentially, he will be entitled to reasonable compensation to ensure that he is put in the same position. So as we can see, essentially, it is restitutionary, the law of compensation under the Contract Act. The party is to be put back in the same position as if there was no breach of contract. Of course, the most important aspect on this is the evidence that the parties lead and the conclusion the court draws based on the evidence. This is the legal position, but a lot of times there is a difficulty on the evidence that the parties lead, and the conclusions may not be exactly what one party may have thought it is likely to be. That is a short précis of the damages under the Contract Act. I think I'll close my presentation here. Thank you very much. I think the learned moderators can take over from here.
Thank you so much, sir, for your thought-invoking views, simplifying the essential requirements of law of damages. Now, may I call upon Mr. Amit Sibal to share with us his views on the topic?
I'd first like to thank Justice Nath for an extremely lucid and succinct overview of damages under the Contract Act. I don't think that the organizers could have chosen a better person to traverse centuries of history and principles in an afternoon than Justice Nath, as we see from his judgments also. He is always succinct as a matter of rule and principle, and we all benefit from it as we have this afternoon. Thank you very much, sir. And thank you to the organizers for giving me the opportunity to be here. Manav Rachna University and Ajay, thank you for your kind words of introduction. Thank you to Bar and Bench and to the moderators. Justice Nath has already outlined the key elements of Section 73, and I propose to go into each of them to some degree, and with a view to taking a cue from what Justice Nath ended his presentation with. Purpose of elucidating the elements is to give the parties and lawyers representing the parties a good idea of how best to lead evidence to achieve the best results for their clients. We find time and again in the history of judgments on contract law, very significant and powerful parties like the Government of India and Maula Baksh being caught out not having led evidence on key issues. They forgot to lead evidence on the price that they could have purchased potatoes with and lost the case. And so these are telling lessons. And so I think it's profitable to be as clear as we can on what the elements are, because that's how parties can know best how to lead evidence on the facts that they have in a particular case. So I will go through those elements, and I will end with some short remarks on how some of these principles might even be relevant to issues that arise under COVID-19, and also some remarks on the numerous illustrations and their significance under Section 73. So as Justice Nath began with, there has to be a concluded contract. You can have reams and reams of litigation. Recently, the judgment of the Supreme Court in Vedanta versus Emirates Trading Agency. There were concurrent findings of the trial court and the High Court in favor of the plaintiff decreeing the suit. Supreme Court first remanded to consider the issue of whether there was a contract in the first place. But the High Court reiterated that there was, and ultimately Supreme Court, after all of that litigation, ended up saying that there was no contract in the first place. So you wasted all that time deciding whether damages had to be awarded because the sine qua non was missing. There must be breach by one of the parties of that contract. There must be loss that is suffered. Without loss, even if there's a contract and there's a breach, there can be no damages. Which brings me to really what is the purpose of damages is, as Justice Nath said, to put the non-defaulting party in the same position as it would have been had the contract been performed. What many have called the principle of compensation or the compensatory principle, again, recently elucidated by Supreme Court in Fortune Infrastructure versus Trevor Lima. And I'll draw a quick distinction between expectation interest and reliance interest at this point. Primary object of the contract law is to compensate the expectation interest of the parties. So protect the innocent parties, defeated financial expectations, and compensate him for his loss of bargain. That's the main focus. That's the expected loss the court seeks to protect. Of course, subject to the caveats of position and emotions that I'll come to shortly. Contrast that with reliance interest, where you want the plaintiff in the position he would have been if the contract had never been made. So, for example, a contract gets terminated, you've spent money, or you've given a security deposit, you want it back. That's your reliance interest. Now, ordinarily, as you can imagine, the innocent party cannot recover both expectation loss and reliance loss. So, for example, a contractor whose contract is wrongfully terminated in breach of contract may want to sue for the expenditure incurred while he was performing the contract, but which is his reliance loss. He may also want to sue for loss of reasonable profit, which is his expectation loss. But the court will never give him both, because if he gets the expectation loss, that takes into account the cost of performance and adds to it a certain element of profit and gives him that profit. So the reliance cost has already been taken into account. So to give him both would be accounting, which is essentially also what the Supreme Court held recently in Kanchudyog versus United Spirits Limited. Which brings me to the next element of cause. You can have a contract, you can have a breach of the contract, you can have loss, but you must establish as a plaintiff that the breach of contract caused the loss and not something else. Now, the courts have generally gone by common sense to determine whether a breach has caused loss. But possibly the most popular test is the but test. So, but for the breach by the defaulting the loss cost. And that but for test most famously was articulated in the old case of Pannalal, Janki Das versus Mohanlal and others of Supreme Court. And the facts were somewhat fascinating. I'll briefly tell you what they were. So the appellant was purchased goods on behalf of the respondent and stored them in Bombay. The appellant was under a duty to have taken fire insurance to secure the goods of the respondent, but failed negligently to do so in breach of contract. But if he had taken the fire insurance, it would have been a standard fire insurance he was obliged to take, which would have excluded any damage caused by fire from explosion. Explosion was excluded. What happened? Take the insurance. There was a huge explosion in Bombay caused by government officials, and the goods were destroyed. Now, the government, in order to obviate unnecessary litigation, came out with an ordinance saying that if you have the standard fire insurance policy, even though it covers explosions, we will compensate goods. Now, since there was no insurance in this case, couldn't be that compensation from the. There was a dispute between the parties as to whether there is breach of contract by the appellant not taking the insurance policy that caused loss to the respondent, even though the policy would not have covered that loss. And the court then was asked to decide whether or not the breach caused the loss. The explosion was a super that broke the chain. And the court ultimately decides by majority that on the but-for analysis was the dominant cause. And but for the failure to take the insurance, there would have been compensated by the government, and therefore the breach caused the loss. It was the dominant cause. The court also goes into foreseeability and takes, if I may put it this way, a liberal view, a wide view of whether the damages were remote, and concludes that they were not too remote. But as you can tell from the facts, there can be differing views on this, and therefore I think it's also worth Patanjali Shastri in this case, and I encourage all those who read this judgment to also read the dissent of remorse, which is an important issue in law of damages under Section 73. It is put in plain English in the section that the plaintiff must prove that the damage arose naturally in the use from the breach or was damage the parties knew when they made the contract to result from the breach. And the plaintiff, you must show that you prove of the kind that the parties knew when they made the contract. Like these principles actually come from the Old English case of Hadley versus Baxendale and have been incorporated into Section 73 from there. Now, I've already mentioned briefly about dominant cause and direct cause, Pannalal Janki Das, and that can be seen as a judgment on the first limb of what is damage naturally arising in the usual course of things. And on those facts, the Supreme Court held that yes, the damage arose naturally in the usual course of things, presumably on the reasoning that if you breach your duty to take fire insurance, then you should know that in the usual course of things, any protection that would otherwise have been available to the beneficiary of the insurance contract should be made available to them, even if it's the result of an explosion caused by a third party. More recently, the Kerala High Court, Justice Fatima Bibi, sitting in the Kerala High Court, as she then was, in an interesting judgment, has gone into this aspect as well and cut through a lot of jurisprudence on foreseeability and remoteness, and come to the conclusion that it's best to just summarize it as a test of reasonable foreseeability, which I find is a felicitous way of describing the concept of remoteness. It encompasses both limbs of remoteness to say reasonable foreseeability. In other words, was the damage reasonably foreseeable? But let me spend a minute on the second limb of that test of remoteness. I've covered the first limb. So the second limb being when the parties knew that such damage is likely to result from the breach of the contract. This, if I may put it, is really significant because it refers to special circumstances that create risk of loss beyond the usual course of things. Damage that is in the usual course of things naturally arising is of course covered, but damage sometimes that is beyond what naturally arises in the usual course of things is also covered if the parties were aware at the time of entering into the contract that there are special circumstances that are likely to give rise to damage or loss. So, for example, and the illustrations, and I'll not now mention the illustrations to save time, but illustrations A and K can be seen instructively as to where a counterparty to a contract enters into a contract with a third party, but does not tell the party to his first contract that he has done so. The party to his contract breaches the contract. The third party sues him for inability to deliver the goods that the breaching party has failed to deliver. He cannot, however, seek damages from the first party who's in breach for the damages that have been paid by him to the third party to whom he fails to deliver the goods. The reason is the special circumstances of the goods having been sold to the third party were not disclosed by him to the first party when entering into the contract. So what will the damages that he can get? The damages he can get are on the date that the goods were to be delivered, what is the difference between the market price of the goods on that day and the contract price? In other words, the difference between what he would have paid to buy the same goods that the breaching party failed to deliver to him in the open market is his measure of loss. Famously, in the Supreme Court case of Karsan Das Thakur versus the Saran Engineering, an issue arose where a party had entered into a contract to buy scrap iron, 200 tons of it, which the breaching party failed to deliver. Now, the price of scrap iron was controlled by the government at the time. Now, unbeknownst to the breaching party, the person had entered into another contract with a third party to supply the same 200 tons of scrap iron by export. So when the scrap iron was not delivered, he then bought it and supplied it. He failed to supply it to the third party, who sued him for damages, and he had to pay damages. He then sought those damages from the breaching party, and you might think ordinarily that he ought to be placed in the same position as if the contract had been performed. In other words, had the breaching party supplied the 200 metric tons of scrap iron, he would have supplied it to the third party by way of the export contract, and there would have been no damages, but he suffered damages, so should he not be compensated? What was interesting about the case was that because the price of scrap iron was controlled by the government, on the date of delivery of the scrap iron, the price was the same as on the date they entered into the contract, even in the open market, because of price control. So the quantum is, as you will appreciate, if you take the difference between the price and the contract price, was precisely zero. And because he did not intimate the party about his contract with the contract, that was seen as a damage that was beyond the usual course of things and also not known by both parties when they entered into the contract. And therefore, on the rubric of remoteness, the damages were refused by the court. That's an illustration of how both limbs test of remoteness played out in a famous case. And the court also referred in his judgment in that case to the illustration K, which will further elucidate what I have suggested. The other famous case on remoteness, also on mitigation, of course, is Murlidhar Chiranjilal versus Harishchand Dwarkadas, where a similar argument was made as was made in Karsan Das, that look, the goods were to be delivered in Kanpur, but the plaintiff was going to take them to Calcutta to sell to somebody else. So please don't take as the rubric for damages the market price on the date of delivery in Kanpur. Take the market price on that day in Calcutta, not Kanpur, which would have given more damages to the plaintiff, and he would have proved the price in Calcutta. So the court rejected the argument, saying that at the time of entering into the supply contract, the person supplying was not made aware that there is any further sale to someone in Calcutta specifically, and actually it was open to the plaintiff to sell the goods anywhere. And therefore, the second limb of the test of remoteness will not come into the picture, and you will simply take the difference between the market price in Kanpur and the contract price on the day that was fixed for delivery, and the plaintiff had failed to prove what that market price was and therefore failed in his suit. Now, specific issues arise in the area of remoteness. For example, when can you sue for reasonable profits? So you enter into a contract as a contractor. The contract is terminated in breach of contract. When is it on the rubric of remoteness, on the test of remoteness, that you can get reasonable profits? Well, the Kerala High Court held in State of Kerala versus Bhaskaran that you can. The 10% reasonable profits were reasonable. The court, you don't have to prove the reasonable profits with mathematical certainty in quantum, and you don't have to prove them with reasonable certainty as a prediction, but you have to give a general estimate of what the reasonable profits will be, which, if you read the evidence carefully, the court will accept, as they did in that case. The principles laid down are more important, that in the law of damages under Section 73, when we talk of reasonable profits, what we are compensating is gains prevented by breach of contract. So the gains prevented by breach of contract become the loss that is compensated by Section 73. Because the contract is terminated wrongfully, you didn't have the chance to make the profit that you expect. What I refer to earlier, expectation is protected. You must prove with reasonable certainty that the defendants did cause the plaintiff a loss and the amount of or extent of that loss. You need not prove the causation, as they put it, with fatalistic sureness, nor the amount with mathematical certitude. On the facts, the court concluded that a 10% profit is taken as an element in preparation of the estimate of contract. Now, normally, as Justice Nath said, no damages in a contract will be awarded for injury to the plaintiff's feelings or for mental distress, anguish, annoyance, loss of reputation, etc. All of these fail the test of remoteness. Ghaziabad Development Authority reiterated that principle in the Supreme Court, where it was a case of delay in delivery of flats, and naturally people did suffer mental agony and distress. The court didn't say that they did not suffer it, but it said that those are sufferings that are beyond the scope of damages under Section 73, which focuses on monetary loss. Of course, there can be exceptions. Damages can be awarded for nervous shock or a state of anxiety suffered by the plaintiff, provided that it was within the contemplation of the parties as a not unlikely consequence of the breach of contract. So it again brings us back to something like the second limb of the test, what the parties knew was likely to result from a breach. The plaintiff is under an obligation to make all efforts to mitigate the loss, a principle upheld recently in the case I referred to earlier of Kanchan Udyog. You must prove, therefore, in evidence that you took steps to mitigate your loss. You must take into account the interest of yourself, the plaintiff, and the defendant when taking those steps. But at the same time, you're only required to take reasonable steps to mitigate your loss. You are not required to go to the extent of causing injury to yourself, to your commercial reputation as a plaintiff, or to reduce the damages payable by the defendant beyond what is reasonable, because after all, the defendant, had he not breached, the loss wouldn't have arisen in the first place. You don't owe the duty to the defendant. It doesn't become a cause of action for the defendant to sue you for failure to mitigate loss, but it is for the court to take into account when deciding whether and how to award damages to you. The court will examine whether you mitigated your loss. The case of M. Lashia Shetty comes to mind, where the Supreme Court looked at a case where the coffee board entered into a contract pursuant to a bid by someone to buy coffee from the coffee board. But of course, the coffee board was a statutory body that had to look at the entire coffee market and ensure that prices were reasonable. and didn't go too high. So after the bidder entered into the contract, the bidder in breach reneged from the contract, withdrew. Coffee board had to sell the coffee to someone else. Now, ordinarily, you would expect that in mitigation, a plaintiff should seek the highest price to sell that coffee, but the board actually had a policy to sell it at a lower price, given the general state of the prices in the market, being the coffee board. And in line with that, it actually encouraged people to bid as low as possible for the coffee, and therefore, of course, made a loss compared to the price at which the bidder had accepted the contract originally. The defendant complained plaintiff had failed to mitigate its loss, but the court rejected that argument, saying that it was not for the coffee board to take steps in mitigation to the extent that it hurt itself, its duties as a coffee board, or the public interest. Muralidhar Chiranjilal also, I don't think any discussion of mitigation is complete without a reference to Muralidhar Chiranjilal, which outlines the two principles that you will put the plaintiff, of course, in the same position that he would be if the contract had not been breached, but at the same time, he has a duty to mitigate his losses. So where the person failed to deliver the goods at Kanpur, yes, he failed, but there was a duty to mitigate. So therefore, you will assume, even if the plaintiff didn't actually buy the goods in the open market in Kanpur, the duty of mitigate dictates that in computing the damages, you will take into account that you assume that he bought the goods in the open market in Kanpur. And what is the difference between the price of those goods and the contract price? This is irrespective of whether the plaintiff actually purchased the goods or not. That's Muralidhar Chiranjilal. Very briefly, one can touch on Union of India versus Ramanayan Foundry and Gangotri Enterprises. It's an issue that comes up in a number of contractual disputes these days, especially where the government is a party. Contracts provide that if the private contractor is, according to the government, in breach of contract and they have suffered a loss, then they can recover the sums due from either the security deposit, earnest money, or the ongoing bills of the contractor, or even in other contracts with the contractor. And in various contracts, the government has attempted to so recover what they see as damages to which they are entitled. So in these two judgments, the court rejects that submission and says that you are not entitled to so recover, because the fundamental principle is that sums of damages are not pecuniary liability that are incurred by the breaching party the moment he commits a breach. They are to be adjudicated, and until adjudicated, damages are not a sum presently due or payable. And therefore, you cannot set off and recover until adjudication of your claim for damages. You cannot set off or recover that amount from running bills, security deposits, etc. Some brief remarks on COVID-19 and situations that might arise. You'll recall I referred to the compensatory principle that a party should be put in the same position as it would have been had the contract been performed by the defaulting party. Now, what if you have a party in a long-term supply contract, say for coal, and it breaches the contract just before the advent of a pandemic? The breach has already occurred. The coal is not being supplied as per the contract. Will damages continue to accrue during the course of the pandemic, assuming that it is impossible to continue supplying coal during the pandemic? So the answer we can offer, in accordance with the principles that we've attempted to outline here, is that on the compensatory principle, if the defaulting party had not defaulted and were continuing to perform the contract during the pandemic, it could not have continued supplying coal. It follows then that even though the long-term supplier breached before the advent of the pandemic, you cannot award damages to the plaintiff for the entire period of the pandemic when it was impossible to supply. You must exclude those damages on the compensatory principle, which works both ways. Not only has the plaintiff to be put in as good a position as he would have been had the contract been performed, but he can't be put in a better position than if the contract had been performed. And if you give him the pandemic damages, he will be put in an even better position than if the contract had been performed. You could argue that the same principle applies with a single sale contract with the advent of a pandemic, where there is no market on the date of delivery for purchase in the open market. How do you compute the damages? But let's take a case where there is a contract to supply, say, helicopters, or even better, hand sanitizers. Contract is entered into before the pandemic. There is a breach in the supply obligation, but during the pandemic, there is still a market for hand sanitizers, but the price has skyrocketed because there's a shortage. Who bears the cost? I would suggest that in that situation, the defendant will have to cover the difference between the exorbitant price of hand sanitizer and the contract price. The reason is, if you look at all the elements of Section 73, they are all fulfilled in that situation. Contract, breach, causation, the but-for test, and it is not remote. While it is true that no one could have foreseen the pandemic, it is eminently foreseeable that if you fail to supply hand sanitizers, then the innocent party will suffer the loss. That is the difference between getting it in the open market, whatever the price may be, on the date of delivery, and your contract price. And therefore, it is eminently and reasonably foreseeable that there will be that damage, even though it is a much greater extent of damage because of the pandemic, which is otherwise unforeseen. This principle arguably goes back to Panna Lal, where you couldn't have foreseen the explosion and the ordnance, and yet the court held that on the but-for test, the defendant was liable for the damages. I must credit some of this analysis at the end to two young gentlemen who published an article recently on bar and bench, which I found in my research, Ram Kishore Karanam and Akash Santosh Loya, and I thank them for this. And they looked at judgments of the UK Supreme Court for this, the Golden Strait Corp versus Nippon Yusen Kubishika Kaisha, 2007, UK House of Lords 12, as well as Bunji SA versus Nigeria BV of the UK Supreme Court, as it's now called, in 2015, on principles of award of damages in the case of supervening events. Just a word to conclude on illustrations. I was delighted that Justice Nath went through a couple of the illustrations of Section 73, because I don't think we read them enough. And I think it pays to read all of the illustrations carefully. They provide important and illustrative paradigms. The Supreme Court has held in Mahesh Chand Sharma that these are useful to elucidate the provisions. The court also held in a larger bench earlier in 1962 that at the same time, obviously, they are subordinate to the main provision. They do not expand the scope of the main provision, but courts will be very loath to ever hold that they are repugnant to the main provision and will generally harmonize the two. I find reading the provisions of Section 73 along with the illustrations serves very useful purpose and actually covers what many pages of a long commentary might otherwise cover. And therefore, I would urge all of the young people watching to read those illustrations in Section 73. And I'll end just by a note of caution that both 73, 74 are most important when it comes to leading evidence. Don't let your client suffer the fate of Murlidhar Chiranjilal or the government in Maula Baksh, and focus on the elements of 73 and 74. Thank you very much.
Thank you, Justice Jayantnath and Amit Singh, Senior Advocate. We were delighted to have the views of both of you. Now, we have received a lot of questions. Some we had received prior to the webinar itself, which a lot of people had sent to us, and some we have received during the process of the webinar. So we will try and take as many questions as time permits. But please, if we are not able to take anybody's question, it is only for the reason that time doesn't permit. So please don't mind in that respect. So our first question I'll address to Justice Jagannath. So the first question that we received was that in a contract, the parties specifically state that the quantum of damages that are mentioned therein are a genuine pre-estimate of damages. Will it be open to the either party to the contract to say that though the contract mentions it as a pre-estimate, but they were not a pre-estimate of damages, but were in the nature of penalty?
Certainly, the other party can raise this defense. This question is covered by the two judgments, especially ONGC versus Saw Pipes. It clearly states that the court will decide whether the amount stated in the contract is it a genuine pre-estimate of damages or not. If the court concludes that it is not a genuine pre-estimate of damages, then it would be treated as a penalty amount, and only reasonable compensation, not exceeding a stipulated amount, would be payable to the party who suffered from the breach of contract. And that is short and simple as that.
Thank you, sir. And the next question is for Mr. Sibal. Sir, in these times, like you rightly mentioned about COVID, it's bound to bring about a lot of claims for damages. Do you think that there is a need for bringing about uniformity in the way damages are computed?
But obviously, we can't have any straitjacketed uniformity because each case turns on its own facts. In fact, to simplify things, even in the course of the afternoon, both Justice Nath and I have given, for example, the paradigm of calculating damages as to based on what you would be able to purchase in the open market on the date of delivery versus the contract price. But what if you can't get exactly the same good in the open market on the facts of that case? What if it costs you a little more to go and buy it in the open market? What if there's no market on that day and you have to buy it a few days later? So in each case, there will be different facts, and therefore it's difficult to have uniformity. Having said that, when you come to issues that regularly arise in commercial arbitration, for example, construction contracts, there is certainly lack of clarity in the law as laid down so far as to what should be the test of damages. And there is no doubt that it is possible to classify claims for damages in categories of commercial contracts. Even within construction contracts, one can have different kinds of damages. The courts have laid down tests like the Hudson test and so on, different formulae. I think it is definitely worth exploring whether institutions that are experts in fields of commercial, particular kinds of commercial contracts, can set out principles to compute damages. The gains are obvious. One of the pillars of the law is certainty, which it will promote. Speedy justice is also something it will promote, because parties will then know what kind of claims are viable and actually limit the extent of their claims at the outset, saving a lot of time of courts and arbitrators, and obviously lead evidence in a much more focused manner. But it can't be achieved without having some amendment in the statute. So it's a big task that you're proposing. But I think it's a task that's worth exploring, and also worth exploring what other countries have done on this.
Thank you.
So the next question is, which we have got is, what is the scope of any of the exception pertaining to proving of factum of damages under 73 and 74? And I would request Justice Jagannath to take up that question.
Well, this aspect is very clearly spelled out in the Supreme Court judgment of Kailash Nath and Associates versus DDA, where the party who has suffered the breach and is claiming liquidated damages, and he has the means to show the damages that he has actually suffered. He must lead evidence to show the damages he has suffered. There can be an exception where it is not possible to lead evidence about the damages that are likely to arise. In that eventuality, the party who is seeking damages need not lead evidence, or he can't lead evidence on that aspect. The typical case is that of ONGC versus Saw Pipes, where ONGC was held entitled to liquidated damages, though they had not led evidence on the damages they suffered, because the nature of contract was such that it was not possible or feasible for the party that suffered on the breach of contract to lead evidence. But where it is possible, they'll have to lead evidence.
Correct. So we've received another question. I would request Mr. Sibal to express his views on this. So you mentioned about the dominant cause effect. Would that also be applicable in cases of contribution?
So contributions comes in when we talk of caution. Kanchan Udyog, the Supreme Court judgment deals with this. So in Kanchan Udyog, what they found was that there was clearly a breach in termination of the bottling contract. But what the court found was that the bottler would in any case have made losses even if the contract had not been breached for so many reasons. Its financial incapacity, the nature of the market, and the failure of the market to accept its brand. So in a given situation, you can have a number of factors that result in causing the loss of the plaintiff. And one of those factors can be the plaintiff's own contribution to that loss. So on the principles of Section 3, the court would look at the contribution of the plaintiff itself towards the loss suffered and can come to the conclusion that there is failure to establish causation in the first place if the contributory negligence rises to that level. If it doesn't obliterate damages altogether, certainly contribution by the plaintiff to his own loss will break the chain of causation to the extent at least of some of the loss and therefore reduce the loss that is available to the plaintiff.
Thank you.
So the next question that we have is that in case of a wrongful termination of a contract, which is for an indefinite period, how do you assess loss of earning or profit in that case? So I'm assuming this question pertains to wrongful termination of a contract of employment. So Justice Nath would want to take it, sir.
Sorry, repeat the question.
Repeat the question, sir. In case of a wrongful termination of a contract, I'm assuming it's a contract for employment, which is for an indefinite period, how to assess loss of earning in that case?
And the principle is simple. The man who suffered from the breach of contract, he has to be put in the same position as if there was no breach of contract. So, if it is for an indefinite period, I do not know, perhaps you mean to say from the date of retirement of the employee. Let's say if the contract is terminated when he was years old, retirement is 60 years. A lot of factors will go into it. He must try alternate employment. If he gets an alternate employment, then he has mitigated the damages. If he doesn't try to get alternate employment, at best he can get the loss of salary and wages, which can be capitalized, perhaps even be capitalized in the sense that you will not get for 20 years, but you will get a substantial amount which will generate to you the income over time. These are all factors which have to be taken into account to determine for the loss of or the loss and damages that this employee may suffer.
Right, and just to add
As-
to what Justice Nath was saying, as he said, there's a duty of the person, the plaintiff employee who's been terminated, to seek alternative employment. And in one of the cases, the Delhi High Court in Satyanarayan Garg versus DCM Limited, Justice Valmiki Mehta refused damages altogether, saying that the plaintiff failed to prove that he actually took steps to get alternative employment. So he was not entitled to damages at all for wrongful termination, even though the termination was wrongful.
So as you said, the lawyer forgot to prove that he had to prove.
That's right.
Mitigation of damages.
Yes. And Justice Mehta elaborates on that and points out, he actually quotes the evidence how frivolous it was on this score. And he says that it was, as he puts it, a self-serving statement that he looked around vaguely for other employment. And he says that that will not pass muster.
Sir, as both you and Justice Nath just pointed out, that mitigation of losses is an important aspect in any claim for damages. Is it open for parties to contract out of that requirement or that need?
Look, ultimately, you will be get only that amount of damages, so that you are put in the same position as if the contract was not breached. So even if you don't have an issue about mitigation of damages, you say party is exempt from it, the damages would be what are reasonable compensation.
So the next question which I have is, do you think that there is a need for reconsidering the interpretation of 73 and 74 in respect of penalty? And a related question, should an amount, even if held to be penal, not considered as an expression of the party with respect to compensation to be paid to the party who is not in breach? I would request Mr. Sibal to take that question.
The origin of the penalty aspect of Section 74, we have to appreciate, is contracts entered into where there is unequal bargaining power and element of exploitation. And so in a situation where one party imposes on the other a penalty, even though the penalty may apply both ways, it is often the case that it is the volition of one party over the other. And in that case, the policy of the law has been that you don't enforce that if the court finds that it is in fact a penalty. And you hold the plaintiff to whatever damages he has been able to prove, and nothing beyond that. And I think it's still true today that there are contracts which are the result of unequal bargaining power, and there are penalties that are imposed at the instance more of one party than the other. And therefore, there is still a place in the law, I believe, for the provision, for the interpretation and approach that penalties will not be enforced as is, unless quantum of damage is proven by the plaintiff. But there is an argument that today in commercial disputes between parties where you can't say there is unequal bargaining power, party autonomy should be allowed to contract for amounts that are payable on the breach of either party. Would it not promote certainty in the law and reduce the length of legal disputes and save the time of all concerned?
Thank you. So we have an interesting question that has just come up. The concept of hot tubbing, and which is basically of experts from both sides jointly discussing the issues in question. What are your views on that? I will request Mr. Sibal to take that question.
So just to put it in simple terms, first of all, hot tubbing is, as I understand it, where expert witnesses of both sides, as opposed to leading their evidence separately in a typical adversarial scenario, will actually have a conversation as between themselves. And the purpose for which this has been employed is to find a common ground between the opposing expert witnesses and therefore shorten the controversy between the parties and reduce the time it takes to resolve that controversy. It is something that is gaining prominence everywhere. And in fact, the recent procedural rules of the Delhi High Court also provide for hot tubbing in leading evidence in suits in the Delhi High Court. It's obvious that in arbitrations, it is deal with because of the greater flexibility in procedure in arbitrations. But and therefore it's obviously a salutary development and should be used. There are often cases in commercial disputes where expert evidence is important, indeed critical, and hot tubbing is something that should be looked at. Question arises in my mind: what if one of the parties refuses to agree to hot tubbing? The Delhi High Court rules, I notice, are voluntary. So in other words, it is only if both parties agree. I would imagine that in most places it's only if parties agree. But if particular rules of arbitration or procedures in forums of arbitration were to provide for hot tubbing as par for the course in arbitration, then you might even take party consent out of it and leave it to the arbitrator to decide whether to have hot tubbing.
Thank you.
And for that matter, a court might be able to decide that hot tubbing is appropriate in a particular case, even if one of the parties is not consenting to it. At the moment, I believe the position is, in a court at least, parties would have to consent for hot tubbing to be employed.
Just one more question. Probably this will be the last question for the reason for lack of time. And I'll request Justice Nath to address this question. So the question which has come up is, if an agreement for lease is entered into between the parties, but because of breach by the lessor, the lessee is not able to run his business for a period of 1 year out of probably a 3-year duration, can the lessee ask for loss of profits on the basis of sales made by him during the period for which he was not able to run the business?
Well, again here, in this case, if the lease is terminated before the stipulated period, the lessee has the obligation to mitigate damages. It would be difficult to believe that, considering there's a glut of commercial space in the city, he is not able to locate an alternate site where he can shift his business or factory or whatever. At best, he can argue that, look, I was paying 100 rupees a square feet. I had to quickly move my business. I'm now paying 110 or 120 rupees a square feet. So the 20 rupees a square feet damage is what the lessor has to pay to him. It is unlikely that the entire loss of profits for 1 year would be payable by the lessor, because you can't ignore the fact that he could have arranged an alternate site. And perhaps there will be disruption of business for maybe 15 days, 1 month. Perhaps he can be urged that at least for that period, for the loss of business must be paid to the lessee. That's it.
Thank you, sir. Due to the constraint of time, we would have to put a hard stop on this webinar right now. I once again thank Justice Jayantnath, Mr. Abid for taking out their valuable time and sharing their valuable inputs and views with us. I'm sure all our audiences will find these views very beneficial going forward in their applications. I also take this opportunity of thanking Manav Rachna University for providing us a platform where we can carry out this discussion. I thank you all.
Thank you.
Thank you, sir.
If ever you are near here. Hello? Can you hear me, Weber?
Yes, yes, Ankit, I can. I'm not
All attendees
sure
are on
about.
hold.
Okay, okay, okay. I think that went off fine.
I think it went on well.
I think both of them spoke very